Okay, with that being said, we are going to go ahead and get started because I think everyone, and if anybody else trickles in, people will trickle in. As a reminder, if you're a panelist, please label yourself as such. Same if you're a student or a coach. And with that being said, let's get started. So, super excited for today just because, look, on our end, as somebody who has been helping to organize some of these tournaments for the past few years and has had the chance to judge some of you guys, it's always very, very fun to be able to see you guys compete, for some of our competitors, to see you guys and all the work you put into the year. But this is kind of a chance for you to not hear from one of these like older college students who's like further removed from high school, but instead somebody who's kind of had to deal with the cases we've put out, and have first-hand experience to see what it's like to be on the competitor side of some of our tournaments. These particular panelists in particular are very good at what they do. There's a reason we were happy for them to have volunteered to do this. They are better than many college teams I have seen, as I'm sure they now recognize, for whatever college circuits they have gone to so far for AMCA. With that being said, once again, that's just a quick rundown of how this day is going to go. First, I'm going to let our panelists all introduce themselves. Then we're going to enter a Q&A where I'm going to be asking a couple of questions that I think they could give some really good advice on. Then we should have some time to break out into a couple of breakout rooms, which is literally going to be a chance to speak to some amazing competitors one-on-one. And then hopefully we'll have some time for last minute questions. I'm going to try to get you all out of here by uh, 1 p.m. Otherwise, though, let's go ahead and get started. With that being said, in terms of introductions, I'm just going to go in the order I see people on my screen. So, McLean, would you like to go first?
Of course. Thank you, Stephen. So, my name is McLean Conlon. I am currently a freshman at Clemson University, and I'm on the moot court team here at Clemson. I've competed in moot court, counting this season, for the past 5 years, so all throughout high school. I actually competed in moot court in a different league called NCFCA, but also through NAMC, and I actually competed in Yale's tournament before NAMC was a thing. So, I've been here from the very beginning in NAMC's various events. I competed at a variety of events across the country, including the Yale and Duke tournaments. And this past year, my senior year of high school, I won first place speaker in the country. My goal is to become an appellate lawyer. I love moot court, and I look forward to hearing your questions and hopefully providing some thoughtful answers. So thank you for organizing this.
Hey, then can we go to Monty?
Yeah, hi, I'm Moni. I did moot court for 3 years in high school. I also did it before NAMC existed, 1 year at Duke. So it's cool to see how far it's come. And I'm a second year at UC San Diego. I've competed for the last 2 years, and I'm also the president of the team. So if any of you guys are competing at our regional in March, might see you there. But yeah, I love moot court. It's like my passion. It's so fun, and I also want to be an appellate lawyer. I mean, that's the goal. But yeah.
Jake.
Hi guys, I'm Jake. I competed in moot court starting my sophomore year, but I only competed in state for 2 years. It was my senior year that I first competed in NAMC. I now compete for Georgetown on the college circuit, who I was quite happy to learn recently became like a regional host. So yeah, I'll also be like hosting one over in March. So yeah, a few years of experience for me.
Then Miriam.
Hi guys, my name is Miriam Davison. I have been competing since my sophomore year of high school in the NAMC circuit, and I'm currently a freshman at Brown University and currently looking to start up a team here. We registered the club and we're hopefully going to be competing in the spring.
I
Uh,
guess I I guess I can go from there. Hi everybody, my name's Eno. Uh, like some of the other people here, I competed in moot court since my freshman year of high school, back in the Duke moot court days, and then ever since NAMC became a thing in sophomore year. I competed at nationals every year since its founding, and last year I was named the third place speaker. Miriam and I are both freshmen at Brown, and we are trying to get a moot court club started up here to hopefully sort of keep that going.
And then one of the last people create a new competition for us. Let's go to Michael.
Say, Stephen, first of all, I feel a little bit offended by Eno's introduction because he neglected to mention the fact that we were partners for 3 years. Um, so no, I'm not going to do the hard thing. Back to you. Yeah, I've also been doing moot court for 4 years. I obviously my freshman year was when it was still Duke, and then the subsequent 3 years it was the national circuit. Um, argued the cases there. Like Brown, Harvard didn't have a moot court team up until this year. Unlike the Brown people, I'm not actually involved on starting this one. I'm just competing on it. But I recently did the invitational at McAllister, which is the used the AMCA case, even though it wasn't an AMCA tournament. I don't think, and I was the second order there. So obviously, like McLean mentioned earlier, interested in keeping this up through college, probably interested in law school if I can get that GPA up. Yeah, definitely happy to talk about any of that.
Okay. So first question, easy one. And actually, we're going to start right with you, Michael. How much time do you think it usually takes, b that you spend before a competition, kind of preparing? Really, what time of year does the competitive season start for you?
So, okay, I will preface this by saying that, I've talked to some people on other teams, and some people did it sort of differently. For us, the way we did it in high school, was we usually read the cases pretty thoroughly, or excuse me, we'd read the case that NAMC put out, the 30 or 40 pages pretty thoroughly, in the few days following Christmas, just so that we'd have that under control, by the new year. And then we'd spend, about work on a schedule of like a case a week, that is a precedent case a week. And then hopefully leave, maybe a week or 2 weeks before the competitions themselves to, write speeches, take notes, things like that. Maybe get a mooting session in there, which I think were the most probably helpful things that happened at any point during the preparation process. And I'm happy to talk about that a little bit later when we get into the weeds of it. I will say, obviously, this depends a little bit on what your competitive schedule looks like. I think for my team, for Team Landau, usually the first competition for most people was like mid-February. And so this schedule gave time to sort of have everything done by then, and then have that extra time to spend, writing speeches and doing other prep that's not just, learning the content. Obviously, if you have, your first competition in March, if you're doing something later, you have more, sort of wiggle room to change things up. If you have your first competition, I don't know what the schedule is like this year, but I think one year there was a January competition. Obviously, if you're going to that, you need to be sort of on top of things earlier. But I think definitely if you get started sort of substantively over winter break, I think that's a good idea.
Stephen,
Yeah, yeah, I think that's a great answer. I'm also curious, maybe to get a different perspective. Jake, when was your season start?
In when I competed in high school, you mean?
Oh, what? Yeah, when you competed in high school.
Oh yeah, personally, my first tournament I think was in February. It was the Georgia tournament. So yeah, generally like later in the year, but we do get the case like very early into the first semester. So you generally have a few months of preparation time that you're able to go through. And then you're able to like plan out arguments, practice a lot, read all of those cases. So you should never be afraid of like being trapped for time. You get a lot of time to prepare generally because how early the case problem comes out. And also like there's a lot of regional tournaments later in the season. So if you are signed up for later regional as well, then you have like even more time to prepare as well.
Time to then, do you have any advice on anything that hasn't been mentioned yet that you think is worth noting on just like getting started?
Yeah, I mean, I think, obviously like I was Michael's partner, so we were working on the same timetable, but I think, I do just want to underscore that like there's a lot of flexibility depending on your individual circumstances, right? Whether like the size of your team and when in terms of like when your first competition starts, you as like Michael and Jake both said, you do have some leeway in terms of figuring out like when you need to like get serious about preparing. The case drops as like pretty early in the first semester. And so, theoretically you could get started in like September or October. I think in practice, I don't know how common that is, but you're certainly like, I think I am a supporter of starting over winter break. It just will be more or less of a time crunch depending on when your first competition is.
You know, that sounds very valid and very fair. So we've spoken, I think everybody's mentioned so far that reading cases over winter break is a great way to get started. But I'd love to learn more about how you actually go about closely reading cases. This can be for the high school NAMC cases we go in. It could also be in your experience in college moot court to the extent you have that. Jake, would you like to get us started on talking about that?
Yeah, the first thing that I would say is the one thing you 100% need to do is take notes on cases because it's a lot more easy to like go back through condensed notes and then like things with a lot of more important details and having to read the entire case because some of these cases do tend to be long. I don't exactly remember what the lengths were for my issue in high school because I had like when I competed kind of a not very complex issue, so a lot of the cases were a lot shorter. But I know at least now in college, and I assume for a lot like some cases in high school as well you get like very long opinions. So you have to break them down, find all the important details so you can go back to specific details instead of having to go through the whole case. The other thing is like taking notes is good because you can figure out for what purpose every case is being put in there for. Like when the board designs the problem, they put cases in there for a reason. So like one of them might have a test that you might need to use. One of them might need to like describe a certain element of the test. And then those are all going to be helpful for different reasons and then breaking down the case very thoroughly through notes and then like trying to find important details tells you exactly what you should use cases for and what parts of the argument the case should apply to. And then generally you would be able to know as well because you're more familiar with the cases when to like reference it in response to a question, for example. So just knowing the cases quite well, reading them thoroughly and like summarizing them in notes is going to be very helpful.
Yeah, that makes a lot of sense. Would you have anything else to add or?
Yeah, I think so. The way that we always did it, at least sort of on my team, was we would meet every weekend as issue one and issue two, we'd meet separately. And every week the assignment would sort of be like, okay, skim through this case, see what you can understand from it, and then we would all sort of break it down as a group all together. And I really did like that approach. I think what I would do, I totally agree with Jake on the point about take actual notes on the cases. So what I would do is often, I'd do a lot of like highlighting, but then I'd also sort of color code my notes sometimes to be like, oh, this point might be really good for petitioner, or this point might be really good for respondent. So you can sort of start to think about like, okay, how does this actually apply to our case? Since like there will be stuff that is more or less relevant. The other thing that I would really advise as you're reading through a case is to really look at the intentionality behind how it's organized. So the syllabus is great, obviously, to get sort of just like a general understanding of like what the issue is. But you can also see, how the majority opinion has been broken up into sections and outlined, and that will kind of generally give you a sense of like what the flow of the argument of the majority opinion is, and then, what sections might be more or less important to focus on.
I think one thing, if I can add on to that, is that we made one of the things that I found most helpful when breaking down, especially the precedent cases, which becomes very important when you're trying to cite evidence in your argument, was breaking down how these precedent cases were cited by the majority or how they were cited by the minority, the respondent and the petitioner. And so we made tables and we just went through all of the cases that we'd read throughout the course of winter break, which obviously was an elongated period of time, and you had them neatly in a table with notes for how you could use them for either side of the argument. And I think that was especially important in preparing for the speeches. That's all I have.
If I could add just one quick point on that as well, on just the issue of general preparation. I completely agree with everything that's been said. I also color coded, and I thought that was extremely helpful. Just one additional note I'd also like to make is that you should never underestimate the value of concurring and dissenting opinions either when you're reading these cases, because very often those will include a great deal of information that will not be in the majority opinion. For example, you'll often find more history in a concurring or dissenting opinion. You will generally find a number of citations to previous cases that you won't find in the majority opinion because the majority opinion is itself the law, so they don't need to cite quite as often. So I would say definitely use those as resources if you can. They are just an excellent gold mine for additional analysis of the legal issues you're going through.
I will say McLean once slammed Michael and I with a quote from it was like either a concurrence or a dissent that we were not familiar with in a round against him, and that absolutely blindsided us. So take his advice.
You handled it well, but thank you, Ian.
Okay, so I've started to get a sense that there are a lot of ways you can pull from cases and a lot of ways you can write about notes to know what you want to do when you start building your argument. But I'd also love to hear about the process about actually going about building an argument. Monty, would you like to get us started about how you turn all of these thoughts and cases you read into actual words on a page or an outline or something?
Yeah, absolutely. It's kind of changed in the way I did it in high school to the way I do it in college. In high school, our coach would like give us an outline of the arguments that we should make, and then it was up to us to like accept those arguments, not accept them, and like expand upon it, write about it. And then now that I'm in college, we read the cases together, but we kind of write our own arguments and do that on our own. And I think that how I've gone about figuring out what to argue by myself is figuring out how these different rules and precedents kind of like map together. And I think that a good way to do this is to look at a case precedent that is most similar, either most similar to your case or is the most recent, because then I think that it's easy to kind of reconstruct the order of arguments that they go through. Like, for example, I'm just thinking of the AMCA case this year. I'm doing issue two. And it's like there's one sort of rule, and then there's this other rule, and I couldn't figure out at first which one I wanted to address first. But I think that when you go back into the cases and you see the order that the judges think that it's important to address these ideas or these different rules, then it's easier to figure out how to format that in your own argument. And I think that your argument really should be building upon each other. And you should figure out not only how the subparts of your argument relate to your broader point, but also how your points relate to each other. I think that I'm always a big fan of just judges that
Um, Monty, I think
like
you're
pass.
cutting out.
Oh, sorry. Can you hear me now?
I can hear you now, yeah.
Okay,
So
sorry. We have really horrible Wi-Fi here. Sorry. But like let's say for example you're talking about strict scrutiny. You obviously want to cite the case that you're getting the standard from, but I think you also want to bring in a case that is has similar facts to what you're talking about that you can either distinguish your case from or say it's just like this, like liken it to that case. And I think that that's an easy way to strengthen your argument. And especially if you're talking about an issue that has maybe a little bit less precedent or is a little bit murkier, the court hasn't always been clear. I think that you really want to use the facts of that case and your case to your advantage. So really focus on, I guess, the nitty gritty of it.
no, I think that's a really good point, and I really like the idea of building your argument based off of how past justices have thought it should be built. Michael, do you have anything to add? Either something you agree with, a different way you go about doing things?
Yeah, honestly, I think, and this sort of goes back to the previous question you asked. I think someone mentioned this, but it's really good, even really early on when you're just reading the NAMC case first, not the precedent. It's good to have a feeling for how the case is organized. There's usually a couple sections, and the first section is just the facts of the case. But then the second and the third sections are where you see sort of the judges of the lower court taking sides. I think if you start there, then you have a feeling for what the baseline is in either case, sort of what your boilerplate arguments that like 90% of people are going to be making are. And then you can take those and you can read the cases and you can like find nicer quotes. And you can contextualize it for the judges and be like, well, in that case, we had, XYZ circumstances. our case is different because blah blah blah, or our case is the same and therefore you should find here consistent with that ruling. Or you can do as McLean was talking about, you can just go do something crazy with the cases because you don't like what's been given to you by NAMC, and you can come up with something else. But I think just to go off Mani's point, you want to have a feeling for what the boilerplate sort of direction that people are going to go in is, and then you figure out how to tweak that and make changes to it and so on and so forth.
If I could also just jump in here very quickly, one other thing that I want to point out, just adding on to what Mani said about, looking at what past cases have said, I would also really say, like, look at the commonalities and like consistencies across cases in the case bank, where if you're noticing that there's a constitutional test that is being applied across like every single case that you have in the record, I think that sort of makes it pretty clear that like you're going to want to invoke that same constitutional test in your argument, right? So like I just pulled up my speech from last year, and it's like, I was arguing the issue of like the judge recusal, and there was a test under Liljeburg about a reasonable person standard that every single case since then applied, and it was like, okay, so now I know that in my speech I'm also going to apply this so that I can be consistent with precedent.
I think those are all excellent points. And if I could just add one as well, I think an excellent way to go about preparing your case is by using syllogistic reasoning. And some of your coaches may have already gone through this already, if you're in the audience. But a syllogism is just a three-part argument. You start with a major premise, a broad principle. It could be like the most famous one used in a philosophy class is all men are mortal, like it's a general principle. The minor premise, the second part of the argument, is applying it to the facts of your case. In that case, in the hypothetical, it's Socrates is a man. And then finally, you end with your conclusion. So Socrates is mortal. So you start with a general principle, apply it to your case, and then bring in your conclusion. I think that helps a great deal. And I think if you can distill your case down to an argument that's that simple, that's only a couple of sentences, that's a very short syllogism, it will also help you because when you're up there giving your oral argument, you may have judges coming at you from all sides, asking you all these different questions that you hadn't thought of before. But if you can refer back to this very simple 2 to 3 sentence argument, you'll be able to answer those questions much more effectively because then you understand your argument well, and therefore your judges will as well.
Actually, quite like that you brought up syllogisms, McLean, because I do think they're an important part of an argument. And I think, as Michael correctly noted, of our panelists and of competitors in general, you are the most likely to kind of take an argument or take a couple of cases and go off the deep end and find something that's brilliant and terrifying. So I guess my question would be, what advice would you give to somebody who decides to stray from the structure written out in the majority opinion? How do you use theoretically the same legal principle, the same legal argument, and go a different argument? Or how do you find a different legal principle or different legal argument within the cases you read?
Well, if I can just offer like one defense of myself, in response to Michael's accusation, that I just tossed aside everything Nancy gave me. No, that is not true. In a sense, it was, but in the broader sense, you cannot make any argument that is not found in one of the cases given to you. I will start off with that principle. Like last year, I argued that we should overturn a certain precedent and standing law on one side of our argument because a dissent in a previous case had made that argument and that it was already fleshed out. There was historical support for it, and I decided to give it a try. But you should never make any argument that a justice in the Supreme Court in the cases you've been given has not already made. So I just want to start off with that point. In terms of bringing in additional material, one thing that I thought was very helpful in high school was bringing in historical background. I thought that always helped me to better understand the legal issues at stake in the case. And judges are also impressed because it shows that you have a strong grasp of the issues at stake. Now, I think in this case, it might be a little bit hard to stand out by appealing to history because so much of this case revolves around history. But I still think if you do that and you go back to the primary sources that are listed in the record and you really get to know them, you read them several times, you incorporate them into your argument, that will both make you appear more impressive to the judges and it will also help your argument if you want to go off the deep end, as Michael so eloquently put it, and Stephen.
I will add to that very briefly. Don't mischaracterize what judges have said in other cases. I think it's very easy, and I've certainly fallen to this trap a few times, to go through the cases and sort of have an eye out for maybe some extraneous arguments you can make that aren't what the case or not what NAMC has given you. And it's not that, I mean, these cases are long. Someone was mentioning earlier, some of these cases can be like, the majority opinion can be 80, 90 pages. So it's very easy to find a quote that sounds really nice and just drop it in your argument and pretend like, that's like this gold standard that no one else has found and it sounds really good. Very often, if you read it in context, it doesn't mean what you think it means, or it doesn't mean what you're purporting that it means. So, you know, and like obviously you shouldn't mischaracterize opinions because that's like wrong, but also from a practical self-interested level, like you might get by with a few judges, but then when you get to the later rounds of a tournament, you get people who've either read the cases in full themselves or lawyers or other people who are supremely qualified and know what's going on. And then you start getting questioned on a poor assertion you've made and your whole case falls apart. So I'm definitely pro finding things that aren't in the NAMC packet. I'm with McLean on that. I didn't go as far as McLean, but I'm with him in theory. But make sure that what you're doing is backed up by facts.
I agree, for the record.
I have a comment to add, but one last just side note as a reminder, you are restricted to the table of authorities. Yeah, pay attention to the context of a quote. And also, justices will misquote each other. If, like, the original case says something else, and then a justice quotes from that case and completely removes the context, the extra context from the original case doesn't really matter. What the justice said, the case said, is what's in the table of authorities. Just I've run into that problem myself, so be wary. Moving forward, I think we have a pretty good idea of kind of how these arguments can be formed now and how they can be written. But I'm really curious to learn more about what the forensic side of this looks like and how you can practice. I'm assuming a lot of people here are oral argument actually delivering these. So, Miriam, could you just give an idea for what preparing for the forensic side of moot court looks like?
I think a lot of this just has to do with practice. Obviously, some people go into this with skills that they picked up from, for example, speech and debate. Um, but there is a very particular way of delivering a moot court argument that I think is distinguishable from those other competitions. Um, I think one of the most important things to remember is that sometimes it feels a bit like like it feels like you're having a dialogue with the judges. You're not simply reading off of this speech that you've written because you are going to get interrupted. And when you do get interrupted, you need to know how to keep the flow of your argument going. And so much of this just comes back to practice. So if you're thinking like the weeks and the months that have led up to this, a lot of the preparation comes from quick, spontaneous practice. You're asked a question on the fly, and you need to know how to handle it. You need to know how to keep your tone steady, or how to shift into another aspect of your speech without making it obvious that you're pivoting so much. Um, so I think much of it just has to do with practice, with scrimmaging. So the week before, the leading up to a tournament, me and my partner would end up scrimmaging Eno and Michael. And this would just be over Zoom. You don't necessarily need to have elaborate mooting sessions, though those are obviously extremely helpful and extremely stressful. It can be as simple as rattling off questions to one another and learning how to deal with some of these oral intricacies.
No, I think that's a really good point. Do you have anything you'd like to add, Monty, or anything you'd like to say about mooting, just getting in practice, practicing that forensics?
Yeah, as far as forensics go, I have like two different things to say. One about your actual speech itself, and then second about your extemporaneous speaking. When it comes to your speech itself, like your written speech, it's incredibly important to have that down pat and memorized. Not only because it looks better when you're not like reading your notes, but also because when you know what you're going to say, like when you've actually written down what you want to say, it makes it easier to answer questions because you've already thought of how you want that to fit into your argument and where that answer will lead you. So I think that it's helpful for answering questions because you're not just answering the question to kind of satisfy the judge, but you can also use that as kind of a building block to get to where you want to go into your argument next. I think the other thing that I'll say about extemporaneous speaking is that you want to be with the judges, you want to be conversational, but not necessarily theatrical. I did mock trial before I did moot court, and my moot court coach was actually also my mock trial coach. And I remember I was doing mock trial, would tell me to do things with my hands and like be expressive, and then in moot court, it's the exact opposite. And then I think that people go too far and then kind of become like boring and blank when they speak. And that's not necessarily the moot court speaking style either. I think that you want to be authoritative, but also remember, I encourage people to actually listen to Supreme Court oral arguments and hear how the counselors in those cases talk to the judges, because it's honestly a little bit, I mean, sometimes it depends, but it can be a little bit less formal, I feel, sometimes than an actual moot court route. But it's authoritative. You say things confidently, but you're trying to convince the judges of something. It's not a all or nothing kind of proposition when you are talking about these things with the judges. You're trying to maybe get them to buy, maybe they won't buy everything, but you want them to buy something. So see how they react to the things that you're saying and kind of adapt to that and try to really reason with them, talk with them. And I think, again, like Miriam was saying, a good way to do that is just to practice and to figure out how to find that balance between formality and persuasion.
I think if you were to try to condense, or at least my advice to try to condense all of this as specifically as possible, if you want a concrete thing to do as you're speaking, I think the thing to remember is to talk slowly. It's really easy to speed up, especially if you have a speech in front of you, which ideally, as Mani said, it should be memorized. But it's so easy to get nervous and you start going and you're going and you're going, and then you're just rambling. And
Talk slower than you think you should.
Talk slower.
It's that constant feedback that you will get from that, like everyone gets from judges. It is like the most important thing to remember. Also, just as Mani was saying about like looking at examples, AMCA publishes AMCA, the American Moot Court Association, is like the college circuit, and they publish recordings of final rounds that are super helpful to watch. And then also, I believe NAMC has also recorded some final rounds of like the regionals and the national competitions that you can get access to that are also really great to look at for inspiration.
And just know that you can faint in the middle of your speech.
Yes.
And you'll still be going.
That was Ames, though, which is the Harvard Law School.
That was the law
wasn't
school level, but there's a very famous moot court video of
you can watch Harvard Ames. Shameless plug.
Yeah. Sure.
Just quickly add, it's right. We do record the finals, and they are on our YouTube channel if you're interested in that. If you don't know the link to it, should be on our website. You can also email us. So I've heard quite a bit about like being responsive to questions, and I think that's a really good jumping off point. This is kind of open to anybody who wants to answer it first. What is the one piece of advice you have, one thing you keep in your mind whenever you get a question? Like a reflex about this is how I'm going to go about answering these things.
Judges are concerned about so when you make your argument, a judge is almost always concerned about, okay, well, if we okay this, what are we okaying in the future? Or conversely, if we say this is bad, if we say this isn't allowed, what else are we saying isn't allowed? That's like one of the sort of central questions that you're always going to get when you're dealing with an institution that cares about precedent. And so when a judge asks you a question, I mean, sometimes you can sort of try to brush things off and you can try to be like, well, that's not our case, especially in hypotheticals. You can be like, well, there's a line somewhere between our case and what's going on in that scenario. I don't know where it is, but like that's different than what we're dealing with here. Sometimes you can get away with doing that, and sometimes that is a good response to give. But I think generally you should try to be as responsive. You should engage as much as possible with the judge's question, because what it shows is like, I'm thinking about ruling for you, but I'm concerned about the consequences of this.
I agree with that completely, and I think you should also strive to be as clear as possible in your answers. If you seem like you're rambling, a judge will interrupt you again and they probably won't be pleased. So, like Michael said, try to be as responsive as possible. One good rule that I've heard is to start off by saying yes, Your Honor, or no, Your Honor, and then if your answer requires more complexity or requires caveats, then offer those caveats. But start off by saying yes or no, so that way at least you're answering the question. And I think that's a good way to go about it. And also, this is just one thing to keep in mind as well. There are cases where a judge will ask you, if we change X, Y, or Z facts of this case, would you lose? And I've noticed that almost all competitors, sometimes myself included, feel like we are required by the rules to answer no to that question, that we have to say we'd win under every single circumstance. That's not true. It might be the case that if certain facts of this case were changed, you would lose, and you should be able to admit that to the judge. But then you should also, immediately after that, explain why that hypothetical is different from this case, and then use it to reinforce your argument. So I would say this: just be very careful that you're not willing to say anything to a judge that you're not immediately prepared for a follow-up on. And if you try to fight a hypothetical, you're going to get an immediate follow-up and you might not be able to answer it. So that's just my main advice. Thank you.
I think going off of what both McLean and Michael just said, really think about the intention behind why the question is being asked in the first place. Like if a judge is giving you a hypothetical, or they're giving you like a line drawing question or something, like there's a reason for that. They want to understand, as Michael said, like how this is going to apply in future cases, because I think he described it as an institution of precedent, right? Even if they're not saying that explicitly. So just always have that in the back of your mind in terms of like, what are the implications of what happens if we win, and then just the other note I would give, and this is more just sort of on speaking style, but something that I've heard a lot of judges comment on is that it can be really beneficial to sort of take a quick pause and collect your thoughts before you answer the question. These questions are challenging, and judges know that you're thinking on your feet, right? So if you need to take a moment to like before you answer, that is completely okay. And often I find that they sort of appreciate recognizing that like you are thinking about the intricacies behind their question and not just launching into like a pre-prepared answer. So I think that can be really helpful also in terms of making sure that your speaking style during like those extemporaneous questions matches your presentational style when you're reading from your speech, and that you're not getting like flustered and starting to rush.
I agree
Yeah,
with
just
that.
sorry, go ahead. Go ahead.
I was just going to offer one really quick note on that. One thing I noticed when I first started moot court was that a script or having notes with me made it much more difficult for me to answer questions, because I would try and think of what questions I might be asked and then start scripting out answers. But in the real world of moot court, that's not how it works. You are likely going to have to think on your feet, and your answer is going to change based on how the judge asks the question. So if you can find a way to get off notes or get off a script, I would strongly encourage it, because it makes it that much more easy for you to answer questions on the fly.
Yeah, and just briefly to add to that, I think it's also really important to be precise in answering questions. I mean, this goes partially to McLean's earlier point about, if you start rambling and talking about other things and they don't feel satisfied, they're going to bring you back and they're going to make you sort of going to beat you over the head with it until you give them something satisfactory. But also, I think there is a tendency, especially for people who come from like a speech background or an MUN background or some other thing, where like honestly, they, the standards for speaking are different and the standards for content are less rigorous. There is a tendency to sort of throw the kitchen sink at every question. But like if this is a strict scrutiny case and the judge is asking you like some nicety about narrow tailoring, you don't want to go into explaining why strict scrutiny is the correct, level of scrutiny or the correct level of review to apply rather than like intermediate. You want to answer the question. So I think also identifying what specifically the judge is picking at, what part of the legal test the judge is picking at, because ultimately that's what you have to do. You have to satisfy a legal test. Then one other sort of minor anecdotal note. Sometimes you will start, especially if you haven't taken that pause at the beginning, sometimes you will start responding to a question and then realize that you're not going in the right direction. And in that case, you don't need to feel that you're going down with your sinking ship. Like you can stop yourself and be like, Your Honor, actually, it's, XYZ. Obviously, this isn't ideal. You'd rather get the answer right in a sense from the first time. But someone in this room has done that. And they've gotten judges points for it. So, like don't sunk cost yourself into giving an answer that you know is bad.
I think I'll ask one last question and then we'll move into the breakout rooms. A lot of talking about, yeah, some really great content about how to answer questions, about how to avoid being on notes to make it easier to transfer to questions. But this can also be a thing where you are like 5 seconds into your argument and somebody asks you a question that throws you off, or like you want to start up on your first point, and then somebody asks you about like strict scrutiny when you haven't even like gotten to half your argument yet. So how do you kind of keep track of yourself and where you are in your argument, while trying to answer questions and responding to people? So like, any advice there? And how do you help judges, like keep track with you?
This is
Yeah.
where it's really important to have a roadmap. This is exactly what you start off with after you get your sort of niceties out of the way, Your Honor, may it please the court. You want to set out each individual point that you're going to make. Oftentimes there are multiple of them. I think last year's case was a really good example of them because we had a specific pronged test and we had to prove each of the prongs within, this was the Joshi case. And so then when you're trying to argue any of these points, you might have to skip around. And if a judge throws you off and sends you to your third prong when you were just trying to start your first, that's where you go. And then once you're done with that, you can wrap it back around smoothly.
I would say you can kind of think of your roadmap almost like like the introduction to like a multi-paragraph essay, where your thesis is almost like we win or lose because XYZ. And then, your signposting for like the arguments you're going to make are like, first petitioner will argue blah, 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 second, blah, 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 third, blah, blah, blah. And generally, when you give that roadmap, judges are pretty understanding of like the direction that you hope to go. And usually they'll help you go there. Sometimes judges will push you, like Miriam said, and just like jump right into your third argument. And in general, you need to follow them there, right? But as much as you can, sort of think about like answer the question satisfactorily, sometimes just like give your whole argument there, but think about sort of getting back on track and wrapping around eventually. I have also had personal instances where like I literally said, "May it please the court, good morning, Your Honors," and I immediately got like a random hypothetical about swimming pools a couple years ago, and I will never forget this. But what I just did there was like I answered the question to the best of my ability and then sort of tried to find a way to tie that back into like what the main thing was that we were arguing and then sort of just like convey the roadmap from there.